First item is the reason for the special meeting is Planning Commissioner training. First item is a presentation of the City of Gilroy Board, Commission, and Committee Member Handbook, training by the City Clerk. Good evening, Shauna.
Good evening, Mr. Chair and members of the Planning Commission. So wonderful to see all of you here this evening at a special meeting. I appreciate that very much. Tonight, we are presenting to you the first ever Gilroy Board, Commission, and Committee Member Handbook. We've personalized these for you, so you'll actually see your own name on these. Yes. And what we're going to do tonight is we're going to cover briefly what's contained in the book and talk to you a little bit about some things that we think are really important for you to pay attention to as you're deliberating through your meetings. And then Jolie and myself are here and available to answer any questions specific to the handbook. And then Jolie's part 2, which is much more in-depth on Brown Act and conflict of interest and other items. So I'll kind of walk you through the handbook. The handbook is really intended for that brand new person who's never been involved in a board, commission, or committee, or what we call advisory bodies. As you know, as an advisory body, you are really serving at the pleasure of the City Council. They've appointed you, and you're here to make recommendations to the council. As a planning commissioner, you also have other purviews, other approval processes that you are kind of quasi-judicial, some of the decisions you make. So the very beginning of this has a welcome from the city staff and city council, just welcoming you to the city itself. As all of you have been here for some time, I won't cover that. The very beginning is the structure of city government, talking about the form of government. We're a council manager form of government here in California. We're a charter city. And then we talk about the council, boards and commissions, your roles, and officers, department heads, and staff. We go into membership on commissions and boards, and as you know, you are all in a 4-year term and appointed by the City Council. We talk about resignations, removals from office, and I know you're familiar with our recent adoption of our attendance standards for the city back in September. So the city has attendance standards now for all boards and commissions. Ultimately, you can miss 3 meetings in a calendar year, and that's it. After the 3rd absence, if you have a 4th, you're just automatically removed from your seat. We talk a little bit about vacancies and then our annual recognition, which just took place just recently, where we have a nice dinner to recognize all of our volunteers in Gilroy. The next section talks about officers, staff, the relationships between city staff and all of our policy body members, advisory body members. And then we go into actually preparing yourself for meetings. And this is something that you as a planning commission, you have significant items that come before you. You have a lot of material that's presented to you. And so we go into depth about how important it is for you to actually take a lot of time, review your material, reach out to your staff liaisons prior to your meetings to really vet everything before coming to the meeting and then deliberating. We also talk about objectivity, openness, the whole public process. So you serve as members of the community, but you also need to listen to the others that come to the city council, or excuse me, the planning commission meetings to help make your decisions. So being open, listening to that process, and then making your deliberative decisions. We talk about conflict of interest, and Jolie will go into depth in that later this evening. And then I'll touch on this because I have this question frequently, remote participation. So the Brown Act allows you to actually participate in a commission meeting remotely if there are certain steps that are taken. So remote participation generally means you're on a business trip, you really want to attend that commission meeting, but you can't be in Gilroy. And so what we need to do as staff is know well in advance. We actually work with the hotel or whatever conference site you're at. We make sure that you're in an open, accessible area. So you have to be, if you're in a hotel, you have to be in the lobby area or a business center, something like that throughout the entire Planning Commission meeting. You also have to allow for public comment wherever you are remotely. And that agenda of that meeting has to be posted ahead of time. So remote participation can take place, but there's quite a few steps that you have to take to actually explore that. So if you ever are in that position, you certainly want to reach out to your staff as soon as possible to help make that happen. And then your remote location is actually on the face of the agenda fascia. So it's actually posted where you're going to be located. Yeah. Yes?
Is it your remote location Is it true your remote location could be your home?
Generally, no. It can be, but it has to be,
Like if you're bedridden or something?
it has to be fully accessible to the public, including ADA access. So, I mean, there's a lot of pieces of that would have to be evaluated. Jolie may want to talk a little bit more about that.
I think that calling in from home would be, I think that would, if you were that ill or something, that would be a medical absence, excused absence. Because what it is it's really to accommodate you when you're traveling or something, and it isn't really intended for people that are ill.
It's just, there was a Morgan Hill elected who, I walked up to his home and he had the agenda posted outside on his window, and he was being allowed to remote in from home because he had childcare issues, so.
Yeah.
Really?
Yeah.
Interesting. Next, we go into meetings. There are various types of meetings. Tonight's a special meeting. Special meetings only need posting 24 hours before the meeting, agenda posting and noticing of the body and to the public. Adjourned meetings take place now and again, so there could be items of business that you have a time frame you need to address those items, but you need to continue them to another date, not a regular meeting. That would be considered an adjourned meeting. We talked a little bit about subcommittees. I don't know that the Planning Commission actually participates as subcommittees, but sometimes you may be on a subcommittee that the council appointed you to. So that does take place once in a while. Quorum, I know you know, or you're very familiar with what a quorum is. So the majority of the body. Then we go into agendas, minutes, procedures, and then the work plan for the advisory body. And Planning Commission is a little unique in that you don't really have a work plan. There's quite a bit of work that's brought to you, so I don't know that you actually develop a work plan, but that could be something that you explore.
So, Shauna, why we're on back to minutes, because we have a new rule about minutes that I need to explain to everybody, because I'm so excited about finding this. It's one of those little things you find. But anyway, in the new revised Robert's Rules of Order, it explains that because we were always, if you're absent, do you have to abstain for voting on the minutes or not? And the new Roberts rule says that if you are not at the meeting, you can still participate and vote on those minutes because you're not approving them for the authenticity or the veracity. You're approving them essentially in a bookkeeping procedural way. So, so you can feel free to vote on minutes even though you've missed the meeting. So that's a new rule that we just found out about, I just found out about, and it's in the new Roberts rules. So, because it always comes up, can I vote? And it's like, well, you can abstain on it, but if, let's say, you have a 5-person commission and 3 people are new and they need to approve the last couple meetings minutes, they didn't have a quorum to vote for the minutes, but then I did some research and we found out that they all could vote on it. So you learn something every day. So
I know with the council, sometimes if a council member is absent, they'll actually watch the meeting video and feel comfortable that they can, approve those minutes as well. The next section of your handbook speaks to meeting management. So the actual proceedings of your meeting, the decorum at meetings, decorum with the public as well, giving everyone the opportunity to have an opinion, and then conflict management. We go into a little bit of conflict management and trying to, assure that everyone's thoughts are heard and respected. We talk about just some real basics on decision making. I thought this was a really valuable piece. It kind of helps people figure out how does that deliberative process work? How do I pull together those thoughts and make my decisions? Motions, votes, and then the role of the chair and responsibilities of the chairperson. Next, we go into relationships, roles, relationships, and responsibilities specific to council advisory body, so yourself and the city council. We are actually in the process, the city council is in the process of developing a code of ethics and values. And so this guide just refers to it because it actually hasn't been adopted yet. But when it is adopted, it'll be presented to all of our policy bodies as well as all city staff too. We really talk a lot about staff and advisory body relationships. Sue and Jolie really are here for you ahead of your meeting, prior to your meeting, available to you to answer some of those questions. And of course, during the meeting as well. Our responsibilities as your staff, our responsibilities to you as the liaison, and then your relationships with other boards and commissions. We talked briefly about the role of the city clerk, the role of the city attorney for our different functions that support you. And then we go into conflict of interest, public records laws, things that Jolie's going to expand on a little bit later as well. So, and lastly, city email, and I will touch on this. You all have a city established email account. We've done that for the Public Records Act reasons, and so that you're not using your personal email account to correspond with each other. Obviously, you shouldn't be doing that, but if you are emailing us or city staff, please use your city-issued email account to avoid having to disclose your personal email and being in that position. So that's your personal guide. Feel free to reach out to myself, Jolie, anyone on your staff for support if you've got questions. And we're here actually now to answer any questions you may have as well.
Thank you, Shauna. Do we have any questions for Shauna?
All right, you're a learned group.
Everybody has that figured out. Thank you very much.
All right, you're welcome.
Next up, we have Brown Act, Public Records Act, and Conflict of Interest Training by Assistant City Attorney Jolie
So
Houston.
I just hit the enter button, right? Okay. So here we go. Shauna touched on this. I didn't, if I'm giving this kind of training to the council or new council members, we get into the charter a lot more. But this is the section that talks about the appointed boards and commission and how you serve as advisory bodies to the council and the city administrator in carrying out their duties. But a caveat to this section is you are not advisory on certain land use decisions like variance, CUPs, and I believe the zoning, if you deny zoning, it's a denial here that needs to be appealed. So you are more, you're one of the few commissions that makes final decisions. So that's just a little caveat, but you are mentioned in the charter. So just this kind of dovetails with the commission handbook. The planning commission, you all know, you act as a body through a voting on a matter. And remember, your statements or comments are not direction, and they must be in the motion. And I think we've all kind of learned that, or I try to catch it when you're making the motion. The Arkan site with the conditions, the attached conditions as amended, or with the addition of the one condition, because doing training on findings and conditions, you, and I've done that before too, you really need to make your findings and your conditions of approval very clear, because they're the record of your action. And sometimes these projects are reviewed a few years later and those staff members are gone, and you want to see who's responsible for building the bridge or who's responsible for doing this, and you go back to those conditions. And I'm finding that more and more with staff turnover, people retiring, those conditions of approval are critical and just memorializing your action. And also the findings and conditions that you have, that staff has prepared, that you review and maybe modify, those also explain your decision to the council when they ultimately review your decisions. This comes up every so often, but previous commission actions, those remain in effect until changed. And we don't have that very often, but sometimes people, want to think that these policies can change just through staff and not with an action of the council or the commission, but that's not really accurate. Anyway, so the city is unique because it has an open government ordinance, and the OGO, as we refer to it, is divided into three main parts: the Brown Act, Public Records, and Open Government Commission. Shauna and I are the liaisons to the Open Government Commission, along with the city administrator. So the Brown Act and the OGO applies to, the Brown Act calls them legislative bodies, the OGO refers to them as policy bodies. And again, just this is a high-level review. Brown Act and the Open Government just requires that all local agency be conducted at public meetings. And you only consider the items on the agenda. The public has a right to comment on all agenda items. And the OGO has some different requirements from the Brown Act with more, a preliminary agenda, more posting, more notice. And we've only done this a few times. If there's late information, it would take a vote of the majority of the Planning Commission to add it. And then there's draft minutes. So just as an advisory, the majority of the policy body, you need to hear, discuss, deliberate, take action on an item within the subject matter. So what you cannot do is you cannot, outside of a public meeting, have a discussion, communications of any kind with 4 members, or that would be a Brown Act violation. So you need to do all your discussions at the public meeting. It doesn't mean that you cannot talk to 1 or 2 other people, but you need to be careful when you talk to someone else to ask them who they've talked to, because you don't want to get up to 4, and sometimes that can be inadvertent. So there was a change years ago in the Brown Act that it used to require that the majority or quorum, if they were talking about an agenda item, they actually had to come to the case said collective concurrence of an opinion. So they had to make a decision or decide what how they were voting. But there was a case called the Wolf versus the City of Fremont, and it said that a collective, that there wasn't a Brown Act violation because they didn't there was no evidence that there was a collective concurrence by the body. So the legislature changed the Brown Act, and so if you're just even in the process of developing a collective concurrence of opinion, it may be a Brown Act violation. So the one thing that you need to know about that is you have to be very careful because the threshold is a lot lower now, and I'll get into some of that. So well, I'm going to get to it here. Well, I'll go back. Oh, this is going forward, and I don't want to do that, Shauna. How do I get back to where I want to be? No. It's going the wrong way.
Let's escape it, and then we're going to go find your...
I was trying to go back, and it was going forward.
How far are you?
Yeah, pizza time. Okay, I did that one.
Okay, so then let's go forward. Right?
Yeah. Okay, then I can go to this one, the collective concurrence. What I wanted to, and it might be on a slide coming up, but you have to be careful because there was a San Jose case where someone gave an opinion on a matter, and San Jose has 11 council members, and so 5 of them had discussed an item, and they had signed on to a memo about Little Saigon, and the one council member that had signed on to that memo had a passing conversation with the 6th person giving an opinion about it, and the local court, it was just a trial court decision, found that was a violation of the Brown Act because it was 6 people, it was a majority discussing the Little Saigon topic. And so you know, just even a passing statement that how you feel about something could be seen as a Brown Act violation, or trying to develop a concurrence of one. So the exceptions to the Brown Act, and this comes up a lot, is individual contacts between a commissioner and a member of the public, that's fine, or staff. A majority of you can attend a conference, community meetings, weddings, funerals, and you can also, there can be a majority of you at other meetings of other legislative bodies. However, one good rule to go by is if there is a majority of the Planning Commission at the BPAC meeting or maybe the council meeting or something, try not to sit together because it looks bad. And I know clerks around the state call it the no huddle rule, just, you know, because if you're all sitting there to the public, it looks bad and you might be very innocent. Yes.
So on that note, even if it's away from the public, let's say at a conference or something, we still should not be making decisions at these meetings that are exception.
No, you could, less than a majority of you at the planning conference could talk about an agenda item, but it better only be 3 of you and not 4. Okay. And the third one better be careful. All 3, whoever it is, need to be careful about reaching out and talking to number 4, because then you've got a Brown Act violation. There is a very strange rule about standing committees. I put a little caution there that a standing committee is like an ad hoc, a subcommittee meeting, but it has a fixed jurisdiction. It has regularly scheduled meetings, and it's less than a quorum of the body. And we don't have any standing committees, do we? For the planning commission? No, or the council? But it's just interesting that there is a rule that if 3 of you were a standing committee, maybe exploring something about, and it had a fixed time, place for meetings, and it had a set topic or jurisdiction, maybe exploring cell towers or exploring rules for signs, and you were assigned this long-term, not ad hoc, but long-term standing committee, another member of the Planning Commission could attend, but only as an observer. You could not participate. You couldn't sit up there with them. You would have to observe as a member of the public. And it's a very strange rule. It rarely, in my whole career, it's only come up a few times. And it usually comes up because the 4th person wants to come and speak, and then you have to tell them they can't speak, and they don't like that. So anyway, but I doubt we really don't have standing committees. And actually, the Planning Commission has rarely ever had an ad hoc subcommittee.
I have a question.
Yes.
Would a town hall meeting that's hosted by the city, would that count as a community meeting or like another legislative body meeting?
It would be another legislative body meeting because they're all, we post them now for Brown Act purposes, just so if there is a majority of the council there, sometimes it's only the mayor that has them. But then if you post it, it doesn't matter who all attends. You're safe. So
would the same be true of like the high-speed rail committee meetings?
The high-speed rail committee meetings, those, if they're sponsored by the city as a community meeting sponsored by the city through the planning department, those are noticed. So yeah, we notice all those. Yeah.
Okay, thank you.
And right now, Shauna and I, we really notice almost everything just to make sure everybody can attend and you're not getting into any inadvertent Brown Act violations. So the one thing about the Brown Act, and we've talked about this, is the serial meetings. That's a series of, one planning commissioner talks to number 2, 2 talks to 3, 3 talks to 4, and you've got a Brown Act violation. And so that's the serial meeting that you have to be careful about.
And then there's the hub and spokes where the one planning commissioner reaches out to these people. It's not like the chain that gets passed on, but it's the person reaching out, and you can reach out to 2 more and be 3, but if you reach out to that third one and end up with 4, you've got a Brown Act violation. And this includes telephone calls, cell phones, and emails. So emails now are a big source of Brown Act violations because they can get forwarded on so easily, and or reply all, and you don't know who all is in there. So just caution with emails. So here's what I'm saying. Don't reply all. Be careful when you forward. And there is the exception about replying all if Christina or Shauna or Sue, someone's asking about availability for a meeting time or a retreat time, you can reply all to that.
I think what we're starting to do when we reach out to all of you, we don't include you in the to heading, and then we'll just blind CC you, but by the salutation, you know it's to the commissioners. That way there's no error in inadvertently replying all or anything.
So if they reply, it's only back
It
to
only
you.
goes back to the sender, right?
That's good, that's good. So the other thing about the reply all with arranging for meetings is you, without that safeguard, but people would have in the past, or they reply all and they say, yes, I'm available for the meeting, but I hate that project and I'm not going to ever vote for it, which you just told everybody how you're going to vote, which is, you know, just say you're available for the meeting or not and save your comments for the public. And this next bullet has come up a few times. I've had planning commissioners or BPAC people or other commissions, and it's commissions, not council, that they want to, they go to a council meeting or another commission, another legislative body or policy body, and then they go back and they want to report what they saw at another commission meeting. And so they do this report to everybody, and what happens is people get excited about what happened or didn't happen, and it's something that could be on their next agenda, and so it could be, or a possible future agenda. So what I found is, you know, the commissions have a report out at the end of the meeting. Save it for your report out at the public noticed meeting. Therefore, your report out is heard not just by your fellow commission members, but by the public as well. And you don't have that dialogue that's going on through all these emails and everything about an item that is likely going to be on your agenda. So, and as Shauna said, please use your, oh, yes, Casey?
Help me draw the line between Casey, the resident, and Casey, the commissioner here. So let's say I have a majority of the commission as friends on some social network, and I attend a other non-planning commission meeting, and I react to the topic that was discussed at that meeting on social media. Would that be a violation, or what hat am I wearing?
Facebook and Twitter and all of that has become a new layer of potential Brown Act violations. And so what I advise is use your city email for all your city business. And if you have a Facebook account, it should be for your birthdays, your got a lost dog, or, you know, I'm looking for a babysitter, just your personal stuff, very personal. If you want to tweet or whatever it is, tweet, Facebook, and on city business, you should have a separate one so you don't blur those, because we have gotten public records requests for Facebook and text and tweets and whatever regarding, and if it's regarding city business and it's on your personal account and your device, we need to ask you to look for it and send it to me or Shauna. So just like the city emails, and I'm advising if you're going to use Facebook and all of that, have your city Facebook and then your private one. So, because it can get blurred, and sometimes personal business can blend into city business, and then I have to decide, is it personal or city if we get a public records request. Rebecca?
So our personal phones, personal email, personal Facebook and social media accounts, those can be subpoenaed?
Well, they could be subpoenaed in a court proceeding, but under a public records request, what we would do is we would say we've received a public records request for all the city council and the planning commissioners, text, social media, they usually just call it social media, which includes tweets and Facebook and all of that, regarding, I'll just say Bonfante Gardens or something like that. And so then we would send something out, Shauna and I would send something out and say, please, we've had this request, please check your private accounts and devices, and if you have anything on there about Bonfante Gardens or, the, First and Main project or something that is truly city business, please forward it to us. And then it also explains if it's purely personal, we don't need to see it. But this keeps, and we just have to do a reasonable, diligent search. And that means we ask you to go look and you respond, and then we want you to send back an email that you've done that search and you have no records, or you have records and you've provided them. It's not to the point now where it hasn't gotten where we go into your own house and search your computers. That's not what that is not as far as the San Jose case got, so, yes.
So back to Commissioner Estorga's question, kind of expounding on that a little bit. We have not given up our freedom of speech just because we're on the commission. We still have the total freedom to exercise our rights and opinions on anything as a private citizen, Sam Kim.
Yes, you do. Yes, you do. But I'll get into how that can affect things later on as well. No, yes.
Well,
Tom?
while we're talking about the same subject, as a planning commissioner, I would expect that any emails that I want to send to the city council as a planning commissioner would go from my city account. But if it's an unrelated matter that's not related to the planning commission, and I want to communicate with the city council, should I be using my city account or my private account directed to the council members?
I would say private, because you're not speaking as a planning commissioner.
Thank you.
You agree? Yeah. So, because you haven't given up your private voice because you're up here. But this voice has been limited a little bit when I get a little further on, so. But anyway, the San Jose case was a big deal a few years ago, and it is the one that has really changed the landscape with emails and social media, and so it's not quite requiring an affidavit that you sign, but we do want, if we ask for something, we do want you to do a reasonable search and just state that you have, and so anyway. So the Brown Act and the Public Records Act, which is included in our OGO, they're really transparency laws. And so for public records are the writings prepared, owned, used, and retained by the local agency. And they have to pertain to the city's business. And so the San Jose case really distinguished, and it went to the Cal Supreme Court, and where the court really focused on was, if it is about city business and it pertains to city business, why can't the public see it because you have it on your home laptop? That it shouldn't matter where it's stored if it's a public record. But it raised a lot of privacy concerns. And how do you go to your legislative body members and say, what do you have on your laptop or your phone? And huge privacy concerns. And so, but it's worked out okay, but the city attorneys across the state have really worked on trying to find how we can reasonably ask for records and get them. But if it is a public record, it would be something that has to do with city business and not purely private. So there's the statutory exemptions. Staff personnel records are not public records. Draft documents are usually not attorney-client records. There's certain police records that aren't public. Appraisals before the property is purchased. So there's some exemption sections where they wouldn't be, we could withhold them, but we have to make findings. The OGO now is just restricted. It doesn't allow the deliberative process exemption. That's a state exemption, but the OGO is stricter than the state, so we don't have deliberative process anymore. Here's the emails about, so their city business. The takeaway would be assume all information is public or will become public. So when you're drafting emails to other planning commissioners or to staff, you should, if sometimes I tell people, count to 10 before you send it, just because it could end up being a public record. And we have statutory process, and if there is a legal action against the city and the city has to disclose the records, attorneys' fees are awarded automatically to the requesting party. OGO Commission, 5 members. As I mentioned earlier, I serve as the legal advisor. Shauna serves as the liaison. They hear appeals of public records requests, any proposed amendments to the OGO, and they receive and review quarterly reports on the PRA requests, which is very interesting to see how many public records requests the city receives. So conflicts. So the basic thing you need, the takeaway for conflicts is having a conflict of interest. It's a financial conflict of interest. It doesn't mean you did something wrong. It just means that you as a commissioner should not participate in making a decision or using your official position as a planning commission to influence or affect a decision that you have a financial interest. And it's financial. This is the Political Reform Act. FPPC is financial. It's not a personal conflict. It's a financial conflict. So the FPPC requires you to disclose, and that would be you disclose gifts or dinners, gifts of $50 or more, and then there's a disqualification requirement. So if you've received a source of income of $500 or more within 12 months, you have an interest in real property of $2,000 or more. The new rule, month-to-month tenancies aren't considered. A business investment of $2,000 or more. If you're a director or managing partner of a business entity, and the gift limit for disqualification is $480. So you have a reporting and then you have a disqualification. So if you received gifts up to $480 from an applicant that's coming in front of you, then you would need to disqualify. And as you can see, the interest in real property and source of income, they're very low thresholds. I mean, $2,000 in real property is very, very low. The new rules that came out a few years ago, a material financial effect is material or presumed if the decision affects these 11 categories that say what is reasonably foreseeable financial effect of the decision on the parcel of real property in which the public official has an interest. And there's many of them, and you'd have to talk to me specifically about them, but there's also a lot of exceptions. If they're doing street work in your neighborhood and they're paving the streets or putting in new sidewalks or new sewers, and everybody in your neighborhood is receiving the same benefit, then that wouldn't be a financial impact. But, so they try to balance it. But the real important rule for planning commissioners, if the decision could affect the value of the real property and of your property, and it's within 500 feet of your property line. And so, and that's boundary to boundary. So, and it is presumed to be material. Years ago, you could rebut that presumption by saying that, you'd talk to a real estate person or you had some sort of appraisal and it wasn't going to make your property go up or down in value, and you could, on your own, rebut that presumption. But you cannot do that now without an FPPC decision. So any questions on that? What I say is just really, if you think you have a conflict, let me, Sue, or Shauna know once it comes up. So when you have a conflict, you need to identify it, refrain from discussing and voting on it. You step from the dais and you leave the room, except for consent items or an item that involves your personal interest, which would be something that involves a property that you wholly own or a business that you wholly own. You could still step down you don't have to leave the room. You can sit in the audience and you could actually come and speak as a member of the public. But it's a very narrow exception. If you have a conflict, you can't participate in closed sessions. You don't count towards the quorum. So if there's 4 of you and someone has a conflict, then we can't have that item. And you can't bring a conflicted person back to make the quorum, so that item would have to be continued until you had some other people back that weren't conflicted out. Rebecca?
If you're a volunteer on the board of a nonprofit or a business that's going to be affected, but you don't have a financial interest, you're just on the board?
That shouldn't be, yeah, you would have to receive an income, yeah.
Okay, thank you.
It's financial. And then, as I say, contact the city attorney or Shauna early. So going into ethical rules, this is different than the FPPC rules, and perception is really key here. And so, as this says, the rules are what you must do, ethics are what you ought to do. So there's a whole area of what are called common law conflicts, and you as planning commissioners will be involved in this more than you and the council, because you do have public testimony, you are making decisions, and in these quasi-judicial where you're making findings and you're weighing and balancing the evidence in the staff report, the evidence from the neighbors, and then the other side of the neighbors, and you are essentially acting like a judge, and you're weighing and balancing this evidence. You need to be fair and to allow the applicant to have a fair hearing. And so you should really be fair and impartial, and if you can't, for whatever reason, then you may want to not participate in that. And I can go into some more of that, but that's where we get into the ex parte disclosure. Do you have extra information that could affect your decision that you're not sharing with the rest of your commission members? But it has to be something that's not in the staff report, or that, and maybe it's something you got from the applicant or when you went out to the site that you believe maybe the rest of your commissioners don't have. And you need to disclose it because it's affecting your decision. and then the public has a right to know what is the basis of your decision. And Sam, you had a question?
Thank you. So back to the ownership of real property, the 500 feet radius from border to border. You mentioned that I can't contact Peter and have him do the real estate appraisal before and after the decision would have been made. You just mentioned that FPPC has to make that ruling, so they'll come out to my house, do the appraisal before and appraisal after the decision?
No, they won't. In the old days, you used to be able to rebut the presumption that even though you lived within 500 feet, you, based on whatever evidence you had, it wasn't going to be a material effect to your property. And some people used to get appraisals or not. But now there is no rebuttable presumption. And if you feel, based on the circumstances of where you're located and the project before you, that's coming before you, that you don't believe that you believe you should be able to participate, you would request an FPPC opinion. And they don't come out and do any appraisal. They just, it's based on the facts and the size of the city, where your house is located, the type of the project, and these are all the facts that you put in that letter to the FPPC, and then they make that determination.
And I don't imagine FPPC is meeting tonight, so if I had a conflict and may have to make a decision, I can't call up FPPC and just talk to them about it prior to me voting.
No, they used to be a lot better about giving some informal advice over the phone, and they don't really do that not as much anymore. And if you want a FPPC opinion, you'd have to work with me or Andy, and we would help you draft it with your consent. We'd send it in, and you need at least a month.
So can a single commission member stop the entire process based upon the need to get an FPPC ruling, or do we just proceed without the rule?
Well, it depends on what the project is. You could, you're allowed to vote on the continuance of the matter.
Okay.
If the rest of them want to continue it. But if you should know before the packet comes out, you should, if you know that there's a big project coming in and it's in your neighborhood and you wanted to get a FPP opinion, you should do it ahead of time. And I've worked for one jurisdiction where there was a council member that had possible conflicts. And so at the beginning of the term, we tried to go through all the big projects coming down the pike and this specific plan or this master plan, and put together a very comprehensive letter. And it took months to get the response back, but it gave some guidance of where he or she could vote on or not vote on. So
okay, thank you.
Yeah, but you can continue it, and you can vote on the continuance unless somehow you continuing it has affected the decision. And I was just looking at that the other day. Abstentions, you have a duty to vote. They don't count towards the quorum. So, Casey?
So I guess a follow-up question based on what Sam was saying. Wouldn't it be if someone voted and either at that time or years later it was discovered that they should not have voted, wouldn't we just disqualify that vote and the action of the board, assuming they weren't a tie-breaking vote? We would throw out that individual's vote?
Well, that gets complicated. There's a statute of limitations for violations of the FPPC, and they'd look to see if that, even though maybe there had been a conflict, did the vote change the outcome of that decision? And let's say it was a 3-2 vote and the third person shouldn't have voted and it would have been a tie. Someone could ask for it to be, maybe the applicant or something could say that, they wanted a rehearing, but it doesn't absolutely say you have to go back and throw it out. It could be that after the fact, and I believe it's a long statute of limitations. It's either 4 or 5 years. let's say you voted and, the project went ahead, it got approved, but they found out, someone turned you in and the FPPC investigated and they found out that you voted, you could be subject to civil penalties. If they found out that you knew and you willfully violated the FPPC rules, there's criminal sanctions as well. And that's a knowing. I know when I'm going to vote anyway. More often than not, it's someone didn't understand or they didn't do it intentionally. So, but there's several different remedies about that. But the one thing about these common law conflicts, there's a personal bias and then there's a project bias. The personal bias is the applicant. You just can't get over the applicant. You have strong feelings about that applicant, and it doesn't matter what he or she says or does or how great their project's going to be. You're going to vote against it. That isn't allowing that applicant to have due process and a fair hearing. I don't think I've ever had that come up. I have had project bias where people really just don't like the project and they say things about the project, or they actually have said, I'm never going to vote for this project. And once it gets to that point and you really can't be fair, that's a time where maybe you should step down as a planning commissioner or even a council member. And you have rights, you have strong feelings, and you can be a no-growther or a growth person, or a bike person, and you don't like the bikes, bike trails or whatever. You can have those feelings, but when you get up here, you need to have the evidence and the staff report and weigh and balance all of it and make your decision based on that, and maybe put your personal biases aside and make your decision on what's in front of you as fairly as you can. So you say, do I have First Amendment? Yes, you do, but it can't interfere with your role up here. So you do have a little bit of a limited when you're sitting up there. And I have to say, some of the court cases, they do look at, there's a council member, there's a case from down in Orange County, Woody's Wharfs, where the mayor appealed an action and had a 12-page why he didn't like this bar, and the use permit was up for modification and was final with the planning commission. He called it up and went into reading this 12-page report about everything that was wrong with this bar, and the court said that he shouldn't have participated because he pulled it up, so he had an interest, and then he was showing that he was not giving them a fair hearing. So, and these cases are all very egregious. And then there's another case called the Nasha case, where a planning commissioner lived next to a project that was coming in, a condo or multifamily project, and he drafted a flyer opposing the project and then wanted to vote on it. And they sued, and that one, they sent it back for a rehearing because that planning commissioner's vote was the deciding vote to approve the project or to deny. It was the denial of the project. So they removed him, and then they sent it back to have a new fair hearing. So the conflict cases, they're few and far between, and they're really egregious facts. And because usually people don't bother to go to court unless it's pretty egregious. There's, I've got some other cases that are sort of kind of funny, but anyway, so I think that is it, unless you have some questions. I don't know, is the Warrior game on already? I was told, I hope we get over before the Warriors game, so any more questions?
Are there any questions for Julie before she steps down?
Sure.
Thank you, Jolie.
And if you have
Oh, I have a-
questions,
I have a
always, reach out to me, Sue, or Shauna, and one of us, will sort it out. Yes, Tom?
I do have a question. I believe the Gilroy's OGO ordinance requires that the planning commission take a class like every 2 years.
Yes.
And so 2 questions are, I haven't seen anything about that class lately,
It's a tape.
but would that count, this meeting tonight, would that count for our training?
No, we have it on tape, so you have to listen to the tape.
And we get notified, I'm sure, I know I've been notified in the past when we're due to take
Yes.
that.
Ethics class?
No, there are 2 separate,
There's
ethics
the
is separate.
1234 that you have to do, which is 2 hours, and then there's the OGO training that we have a tape now.
Yeah, the OGO training is city, and the ethics training is, I think, FPPC.
Yes, it's the AB 1234, and the AB 1234, compliance, it doesn't, you won't get kicked off the commission or anything, but the biggest fear as a commissioner I would have is if there's a public records request about who's in compliance and who isn't, and because the forms are public records, and anyway, that's it. Shauna, you have anything else to add? Members of the public out there? Oh, sure, and again, if you have questions, I know there's specific rules about real estate brokers, insurance agents, architects that practice in the same jurisdiction, and there's a whole set of rules for those that, I'm not going to bore you with, but those are the questions that you'd need to talk to me, and we'd figure out what it is and how it applies, and you have that map, and so if there's a project that's with, look at that 500-foot map and figure out if you think you can participate, and then ask Sue, me, or Shauna. Okay.
Thank you very much. If there's no other questions for Jolie,